Heerdink, and I would reserve 3 minutes for rebuttal.
3 minutes, yes, sir.
And if I may take 1 second, I just want to introduce to the court our newest associate, Jennifer Powell. She just joined our firm and passed the bar.
Well, very good and welcome, and perhaps we should make her do the argument this morning.
I tried to persuade her this morning. I don't think she was having that, Your Honor.
Nothing like ambush of a brand new lawyer.
Right, deer in the headlights look. Absolutely.
Judges are supposed to do that, so, anyway. Well, congratulations.
Thank you, and may it please the court. For the court's background, we're here today over an issue involving an order of voluntary dismissal that was signed back in November of 2020. November 6th, the order was filed in November 2020, and that order, beside the therefore language, explicitly said that the lawsuit was dismissed, voluntarily dismissed without prejudice. That order was lodged or the notice was lodged or filed in the order entered. Subsequent to an order for sanctions and attorney's fees signed by the court on October the 28th of 2020. At this time, I had just recently come into the case while that motion was pending. But for context, Your Honors, this underlying case was originally filed on April the 20th of 2019. And this order for sanctions was filed or signed by the court on October 28th of 2020. So we have a period of 18 months that this underlying action was pending. And I'm sure we all can recall a global pandemic during that time as well, during the first part of 2020. The order at issue when it was entered gave fees, awarded attorney's fees associated with what the order said with plaintiff's delays for prior hearings and for motions to withdraw from prior counsel. That order had mandatory language that stated the defendant's attorneys shall file an affidavit with the court to be approved for the approval by the court.
And that order went down before the order of dismissal?
It did, Your Honor. It was signed on October the 28th, and the order of voluntary dismissal was signed on November the 6th. The notice was lodged on November the 5th.
So they had the right to recover attorney's fees before the case was dismissed?
Yes, Your Honor. It said that they shall submit shall submit an affidavit for approval from the court. It's a mandatory language. Our position is that created an obligation on their part to do something.
Agreed.
That was not done.
Well, it was done. It was done months and months and months later. Correct,
Your Honor. That would be my position. There was one order or one affidavit filed by counsel for defendant Garrett, albeit outside of the 30-day window for where they could have filed a motion to alter and amend, like the Minchie case that's relied upon by the Appellees. They did not file anything within that 30-day time period to alter and amend this order of voluntary dismissal to include any award for attorney's fees.
A civil action, the judgment for a civil action does not constitute a final and non-appealable action until all claims and counterclaims and issues have been resolved. And it appears that an issue was unresolved, and that was the attorney's fees. So it wasn't a final judgment, and therefore the 30 days hadn't started.
Yes, Your Honor. I would submit that it's in opposite to just the Minchie case that is relied upon by the Appellees. In that case, is a little bit factually different because there was a pending motion for summary judgment, so that required the agreement of the parties. The language of that order especially state it was only dismissing the appellant's claims, whereas our order says that the lawsuit is being dismissed in its entirety. The parties recognize...
There were no counterclaims in this case.
No, Your Honor, there were not.
Correct.
And in that Minchie case, the court had reserved awarding attorney's fees for granting 3 separate motions to compel. So within 14 days after this notice, order of voluntary dismissal in the Minchie case, within 14 days, they filed a motion with the court to make sure that those attorney's fees were dealt with. And it was. And that was a point that the court addressed in the Minchie case. Here, there was no action. There was no action by the defendant Osborne in the underlying case until 26 months after the order had been, or the order for voluntary dismissal had been signed. That's longer, Your Honor, than this case was even pending. For over 2 years, no action was taken. I know in the Appellee's brief they cite to some confusion. I don't know what confusion everybody was aware of what had happened in that case, and that a new case had to be refiled after that fact. I would submit two arguments. One, a plaintiff has a right to take a voluntary non-suit absent explicit exceptions, and then what's relied upon here, the implied exception of a vested right. Black's Law Dictionary defines vested as having become a completed, consummated right for present or future enjoyment. It's not contingent, it's unconditional, it's absolute. I would submit that the order required the plaintiffs to take some action. It said they shall file an affidavit to be approved. That was not done until 26 months down the road. That then also kind of brings in the theory of, was there a waiver? I would submit it is our burden under the case law to prove that the appellee waived some right or some claim of relief that they had. I would submit that the record's clear that they did that. There was complete inaction for 26 months. Otherwise, to rule differently, they could have had years. It could have gone on. Their right to file an affidavit could have gone on in perpetuity, and they could have come back 10 years, 15 years down the road, theoretically under the non-waiver argument, and filed their affidavit and still been entitled to recover their attorney's fees. At some point, there has to be an indication that the party has waived the right. And I would submit that 26 months is a clear indication that they're not taking any effort. And frankly, I think all parties thought that the case had been over and was resolved. The court took no action. There was no other motions by anybody. Defendant Garrett's attorney did file an affidavit, but there was no action taken by the court because the order of dismissal had been signed. There was no motion to follow up filed by anyone. I think it's clear that everyone understood that this case was over. I don't know what changed in January of 2023 for a motion to come out of the woodwork, but I would submit that this potential for recovery of attorney's fees was waived due to the 26-month time period.
So, the other defendant, Garrett, filed an affidavit for attorney's fees a month or so after the November order of voluntary dismissal.
Yes, Your Honor.
Is that correct? So you don't have any problem with that one? I
would still submit, albeit the court's obviously pointing out that it's not a final appealable order. I would submit that it had already been dealt with. During that time period, there was just no action taken. The court had dismissed it, and then I think it was 33 days later that this affidavit was filed. I think that there should have been, in that time frame, a motion should have been filed, something should have been done within that time frame to alter and amend, like they did in the Minchie case. They immediately, within 2 weeks of that happening, of the order of dismissal, they filed a motion with the court to make sure that there was not going to be an issue with their award of attorney's fees, and the court addressed it in the Minchie case. That didn't happen here. Like I said, I think everyone at that point in time considered and thought that this case was done and over.
Well, defendant Garrett didn't think it was done and over until their attorney's fees were addressed. That's not part of this appeal, though, is it?
Correct. They did not. They filed no response. We're strictly appeal. They didn't take part in the motion in the trial court that was filed by counsel for defendant Osborne. We are strictly here dealing with that one order that was granted or said that they shall pay.
Now, the other defendant got their fees, didn't they?
No, Your Honor. There was not ever an order entered by the court approving any affidavit, and that kind of goes back to my argument. It appears, for all intents and purposes, that everyone thought that this case was done and concluded. There was no action ever taken until the affidavit and then a motion to enforce filed in January of 2023. And I've touched on my waiver and abandonment argument, Your Honor. I think that it's clear that there was a decision here made not to file anything for a period of 26 months. And at some point, The cases that we've relied on in our briefs, I know I relied heavily on the Rose case, which I think is more analogous to this situation. At some point, a party cannot continue to sleep on a right that they may have, and then come back 2 years, 3 years, 4 years down the road, and then say, oh, by the way, this order that was entered before this case was dismissed 3, 4, 5 years ago, I can come back now and get my attorney's fees. At some point,
Do you agree that the trial judge's decision on the waiver issue would be subject to the abuse of discretion standard of review?
I would tend to say probably yes, because it is tied into the award of the sanctions. I would submit that 26 months, I would submit it is an abuse of discretion at that point in time. I mean, if we're within a couple of months, maybe there's more of a better argument, but when we're more than 2 years down the road, and again, like I pointed out, when that period of time exceeded what was claimed to be a delay on the underlying case, in that case it was only pending for 18 months, I just don't see how those can comport with each other.
And if I understand it correctly, you are not disputing the amount of the attorney fee awarded, but the fact that any attorney fee was awarded.
Correct, Your Honor.
Okay, thank you.
And I'll save the rest for a rebuttal unless the court
We'll
has
hear
any other
from you
questions.
on rebuttal. Thank you, sir.
Thank you, Your Honor.
Good morning.
Members of the court, good morning. Thank you for having me. It's always an honor to be here before the Court of Appeals or the Supreme Court. My name is Jason Reeves. I'm from the Bedford County Bar. I represent defendant Osborne in this action. Attorney Richard Duggar is here with me today. He represented and continues to represent Mr. Garrett in the Bedford County Chancery Court, where this action stems from. My understanding is that Mr. Duggar is relying on my arguments here today. I'll be as succinct as I possibly can in this case.
Now, did he file a brief?
He did not. He
Okay.
essentially is relying on what I've done in this case, and it's to avoid duplication of efforts and the expense of that.
But he's not raising any issue, and you're not raising any issue. You're just defending the issue raised by the appellant.
That is correct.
Okay, thank you.
That is correct. Procedurally, this case and the underlying facts of what gave rise to this cause of action really are irrelevant to the case. What is relevant is that plaintiff filed a lawsuit. There were significant delays. There were multitude of lawyers for the plaintiff involved in the case that contributed to the delays. There was failure to obtain experts that contributed to the delays, as a result of which I filed a motion to dismiss that was heard in October of 2020. And the court agreed with me, but didn't go so far as to dismiss the case. But what the court did do is it prevented plaintiff from being able to use an expert at trial, and it found the right to attorney's fees for all the delays caused by the plaintiffs. Of course, as these things happen, at that hearing, no one knew exactly what the amount of those attorney's fees were. They're billable hours, they accrue, and so the court required us, as the court often does, to file affidavits for that. However, 5 days later, plaintiff non-suits the case. And that entry of the non-suit created some confusion early on as to whether or not, at that time, that right would extend. And so we had to do some looking at that as the defense counsel. Mr. Duggar, on behalf of his client, did file about a month later his affidavit. There was confusion between Mr. Duggar and myself as to what had occurred with relations to his affidavit.
All right, now that's where my confusion is. I was of the impression that the Garretts had been awarded their fee, but what happened, they filed their fee application, but an order approving their fees was not entered.
That is correct. So
Okay.
the affidavit was filed with the court. I never received a copy of it at the time.
I made the false assumption that the deed was done. All right.
That's right. And
So their fee application is still pending.
their fee application is still pending.
Okay.
We were going to be working together to file a joint motion to do those things, and I never knew that was filed. And what triggered this some months later was Mr. Duggar and I were in court talking about this case. We actually had to go pull the old file because there was This case is still pending. It's been rebranded under a new case number, but the exact case is still pending before the Chancery Court.
Case number?
It was a new case number in the Chancery Court was granted to that. And there's been filings that should have been in one file that have been in another file, and confusion reigned. So Mr. Duggar and I pulled it, and we noticed, and he recalled, oh yeah, I did file that affidavit. And I said, fine, I'll file my affidavit and the motion. I did that, set it before the court. The court heard that, and the court said, yes, your right to attorney's fees was determined before the non-suit under Minchie. The amount of that attorney fee was undetermined, but the right to recover whatever attorney's fees had accrued, I had given to you. The court also found that the confusion going through the COVID years, when the affidavit was filed, that the court didn't act on, whether that attorney's fees continued over after the non-suit, because Mr. Duggar's affidavit was filed in December, and in January, plaintiff refiled the lawsuit under a new case number. And the only difference in the new filing was there were two new defendants and new claims as to those defendants, but the original claims, the original parties, that lawsuit still exists. It's set for trial week of Thanksgiving this year. And so they want to argue waiver and undue delay. This case has still been pending. It's still been active before the court, albeit under a different case number. Same parties, same claims. Now, the court found...
You say this case is still pending, but they revived the action by filing a new lawsuit.
Correct. Okay. That is correct.
So it's a separate civil action.
It is a separate civil action involving the exact same parties and the exact same claims. And so that, again, contributed to some of the confusion as to where we were at in the case. Nevertheless, the court heard that. The court accepted the reason for the delay in filing that. The court agreed that the right to attorney's fees had been established prior to the non-suit, and that's what's critical in this. As it relates to the non-suit, if the right existed prior to the non-suit, that right doesn't go away. It still has to be adjudicated, and that right still exists, whether that's an attorney's fees, whether that's a counterclaim that's been filed by a defendant, whether that is in an action where the government's taking land. If the taking has occurred and the right to taking has been granted to the government, but the determination of the damages has not yet occurred, the government can't get out, can't non-suit, because the right still exists for the landowner, right? And so this is the same concept here. That right was established in October of 2020. The non-suit occurred in November of 2020. And so the right still existed there. And as the court noted, it's not a final action because that right was still hanging out there. It had not yet been determined by the court. And I think that this confusion with the refiling, the new case number, and all the issues that we've talked about is what led to that. And the trial court heard all of that in the motion hearing. The court agreed with us that the right was there, that the attorney fee was proper, and it should be awarded. The court was very specific in citing Minchie and the analysis thereunder that there was no prejudice to, in this case, the plaintiff, because again, the case is still pending. And so because of all of those reasons, the trial court acted appropriately, did not abuse its discretion. And so to be quite blunt about it, the right existed before the non-suit occurred. That's what takes this out of the normal non-suit. We don't take issue with their non-suit. They had the right to do that. It just doesn't change our right to recover attorney's fees. And that their claim of waiver, they've not been able to satisfy abuse of discretion. And we'd ask the court to uphold what the trial court found and allow the attorney's fees to stand.
All right, thank you, sir.
If there's no other questions?
Hearing none. Rebuttal.
May it please the court. The talk of this same lawsuit leading to confusion, it doesn't tread water. The case, when we non-suited and revived by filing, had an entire group of defendants because the appellee had actually sold the property that was at issue. So we had to bring in a new set of defendants, albeit two of the original defendants were still in. New case number. new defendants, new case number. The fact that you're confused because there's a new case number, you know whether or not you have a right, what that order would have said. I'd submit, this is, and I cited in my brief.
Was any evidence introduced that is before this court, either in a transcript of the evidence or a statement of the evidence, to explain why there was a delay or the justification for the delay?
There's a statement of evidence that was provided to the court. There was no transcript of the hearing. I don't recall a valid reason other than
The
confusion.
statement, and I asked that, to be fair, thinking there probably wasn't, because this would just have been a hearing on the right to an attorney's fee. But
Correct.
So you're saying there is a statement of the evidence from that hearing?
No, Your Honor. It's a statement of the evidence that basically lays out procedurally what has happened with the case. It wouldn't have been directly related about testimony or
Well,
argument
that
of the.
wouldn't be a statement of the evidence. Statement of evidence is just a substitute for a court reporter's transcript. All right, so there is a.
No,
we
Your Honor,
don't, we don't have any evidence on why there was delay or why there wasn't.
No, Your Honor, other than what was incorporated into the order. I don't think COVID delays at this point in time in 2023 would have related to anything. But, Your Honor, I would go back and kind of point out the Rose case, because it's very similar to what happened here, and that's the one that I relied heavily on in our brief. While a motion was pending, the appellant in the Rose case took a non-suit of their case, provided notice the day before a hearing on the motion filed by the defendants. And the court proceeded anyway on that motion and granted a motion for fees. After that, the order for dismissal was signed. It's very similar to here, except for in that case there was an amount. In our case there is not an amount. A motion to modify was filed, and then an order was later entered granting the fees. On appeal, the court said that absent the implied vested right or the expressed exceptions to the rule, you have a right at any point to take a non-suit. That there was no order altering the dismissal in that case, like here, and the action ended by plaintiff taking a non-suit. And that was effective on the date the notice was given, not the order signed. And so I would submit here, I'm out of time.
Well, you can finish your thought, but I'll ask the question. In our case, your case here, the notice of non-suit and the order of non-suit were both filed after the order went down declaring that the defendants were entitled to attorney's fees.
Yes, Your Honor.
Okay, thank you. All right.
Thank you.
Thank you, Mr. Jenkins and Mr. Reeves, for your arguments. We'll take the case under advisement. And Mr. Duggar, your argument was very effective too.
Judge, I'm getting old, it's good to come up here, but I drove around 30 minutes trying to find someplace to park.
If people would quit coming, we would be so much better.